All right, this will be the People News, okay? We're going to do another video because I'm led to believe I did too many videos at one time, lots of times. This is from Father in Exile, okay? You need to check out his video because he actually has a lot of Supreme Court cases in California, which would be the Ninth Circuit. And it is all very different things. And he has a little issue with the family courts as well. And he brings up Susan Bassey. If you guys haven't checked her out, she's just plain out awesome. And she's calling everybody out. She's after the cops. She's after these crooked attorneys and these crooked magistrates. They're not judges. They're magistrates, and they are forcing their will in administrative. Okay? And technically, they have a right to do that because of the 4D program being a contract law situation. But since they don't let you know when you challenge jurisdiction that is contract law, then it misleads the people, and them judges and magistrates and all them are wrongdoers. They're liars and thieves, and F the AG of every single state for signing the contract. You piece of... I get a little aggravated on family courts of everybody. Sorry, I digress. Let's go ahead, because it's not all about me. But I'm going to bring it about me. This will be the People News. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Never trust the attorney, even though there's something good. Do your own research, okay? That way you can file against them if they do something wrong, all right? And, of course, it won't do no good, but, you know, you'll feel some type of empowerment by doing it anyway, okay? What was the other one I was going to say? It's education purposes only. Okay, I'm not an attorney. There's no such thing as me giving legal advice. Why? Because I never signed a contract to be a bar union thief. All right? I never signed a contract to be a liar. All right? And I never signed a contract to give consent to all these government officials to be a bunch of damn liars. Let's go.
Internet, it's February 27th, 2025, and tonight I have a special treat for you. Someone has leaked video footage to me from the Santa Clara County Superior Court, specifically Judge Cindy Seeley Hendrickson's courtroom. If you've been watching Susan Bassey's channel at all, you will know that Judge Hendrickson recently threw court watchers out of her courtroom when they served her with a disqualification motion. Closing the courtroom to the public is something that I'm going to be challenging in my federal civil rights lawsuit. Right now, in my federal civil rights lawsuit in San Francisco, California, I am challenging the Santa Clara County Superior Court's rule that says no recording in the courtrooms and no recording in the publicly accessible areas of the courthouse. The judicial defendants have already filed their frivolous motion to dismiss, and I'll deal with that in a couple weeks when I have to. Right now, I'm working on several motions for preliminary injunction. The first motion for preliminary injunction that I'm filing is to ask the federal judge to order the court CEO to give me remote access to my court file. The next motion will probably be the no recording motion. Anywho, somebody leaked me this video footage anonymously, and I want to show you today the video footage. It's only a few minutes long, but it's emblematic of what's going on in the California Secret Star Chamber courts. Specifically, when Judge Hendrickson was served with a DQ motion, or statement as it's called, she should be removed from the case. She has no jurisdiction to be doing anything until that disqualification is ruled on. What is supposed to happen is that disqualification goes to a judge outside the county, and that judge makes the decisions on what kind of proceeding to have and whether or not Judge Hendrickson is disqualified. Now, back in 2021, when I was doing disqualification statements against my judges, they would just strike them illegally. I took that issue all the way up to the California 6th District Court of Appeals as well as the California Supreme Court on a writ petition. The problem is writ petitions are discretionary, and both those courts summarily dismissed my writ petitions without any explanation whatsoever as to why. So that also is an issue in my federal civil rights lawsuit, saying that the pattern and practice of striking the disqualification motions violates the 14th Amendment. Anyway, I'm going to show you this video now, and then I'm going to send you at the end over to Susan Bassey's channel so you can get the backstory on this. I would appreciate your help spreading this video far and wide. We need cameras in the courtrooms now, Again, this video footage was leaked to me anonymously. I'm going to show it to you the way that I got it. I am not editing this footage at all. Hopefully by next week, my motion for preliminary injunction on the no filming rule will be filed. If the court does not...
And this may be a kind of short because there was a cut right there. So he may not have another video of the whole thing. But let's go ahead and proceed forward on this.
voluntarily agree to remove the rule, I will seek a temporary restraining order until the judge rules on the preliminary injunction motion. Now, some of you lawyers and judges out there will say that Judge Cindy Hendrickson did nothing wrong in this video because all she did was set a date on a calendar for a status check. While technically that may be true under the civil procedure, here's the problem. Cindy Hendrickson has already shown that she will shut down her courtroom to the public, and there are no cameras in there. In this instance, this litigator had a lawyer. He's the man in the top center of the screen. Lots of litigants do not have lawyers and do not have people watching the courtroom to protect their rights. How many times has Cindy Hendrickson done things that she shouldn't have been doing in secret? I also want to point out that the lawyer costs money, so this litigant was burning through cash just to have that person sitting there. And if that litigant wanted to have a transcript of this status conference, that's $1,000 for a court reporter to show up. If you don't know about the court reporter scandal and lawsuit going on in the California Supreme Court right now, again, go over to Susan Bassey's channel, you'll learn more about it. To Santa Clara County District Attorney Jeff Rosen, scumbag, I'm telling you that I'm publishing this video as a First Amendment protected activity. Anything that you do to retaliate against me for publishing this video given to me anonymously will be met with an amendment to my lawsuit, adding another First Amendment retaliation claim. That's it for tonight. Enjoy the video. Please help spread it far and wide.
Which is was indicated by the counsel that I should file the paper that was filed. Now, when I say filed, it was submitted on February 20. It has not come through as filed yet by the clerk. I know the clerk is often backed up, but that document is mentioned that document includes email communication to Ms. Ford, where we requested that she, on behalf of respondent, try to reach agreement with the petitioner on the judge that would hear the disqualification. We did not hear from her, and so we filed the paper mentioned. I'm not clear what opinion the court is referring to. At this point, the procedure would be that the matter of disqualification be referred to another judge and heard by that judge, with the option of that judge, him or her, conducting a hearing if they wish. We also have the opportunity to reply. So that is where and which we will be filing a reply with some supplemental information. So that is where it stands. I just want to be clear that we're not waiving our pending disqualification or in any fashion compromising it by attending this hearing, and we understood it to be simply a status conference hearing. And so I am not clear what opinion the court refers to. I don't see where that would be within the process of 170.1C5.
This is a status conference. All I'm doing is setting a next date. I've been advised that I can do that properly with a 170.1 pending. I have March 18th at 9 a.m. where I could put this on for further status conference.
I'm not available, Your Honor.
Well, I am, but
My calendar on the 17th, in the afternoon of the 17th, even though that's not a status conference calendar,
I'm not
slightly
available,
set.
I'm not available.
Then how about either March 24th at 1:30, March 24th at 9 a.m., or March 25th at 9 a.m.?
We're already here, Your Honor, at 9 a.m. On this case. So why don't we just set it there, and then we can, depending on what happens with the disqualification, we may have to move that. That's the return on the child support motion. So we're already here on that date. So we can just change it to a status conference.
Is everybody else available on March 25th at 9 a.m.?
That date is still available for me, and I have already planned to be here, Your Honor.
Mr. Evans, are you available?
yes, I am, Your Honor. But I have a concern that it's the same day as something already scheduled apparently regarding custody.
It's not
Obviously,
custody, it's support counsel.
all right, fine, whatever it is. That we're under a disqualification procedure at this point. So unless and until that is resolved, the court cannot move on these items, custody, support, what have you.
And counsel, I made that clear that since we were
Understood.
already there, I was just asking that we move it because then we'll have to move that date anyway.
Then we will add to the March 25th, 9 a.m. calendar.
Alrighty. Keep an eye on everybody. Alright. So if you don't want to learn the whole process, at least know enough of what your attorney is going to do for a grievance, bar grievance against your attorney. Now, that being said, when you file a bar grievance against your attorney, it's most likely because he broke the contract to be able to protect you in court. Now, always listen to this, because this happens a pretty good amount of time. The attorney is going to tell the judge that he wants to leave you. Okay? Deny that. Alright? And also bring up that you may file another bar grievance and you cannot hear him speak that way, or she, right? Because he just released attorney-private conversation, attorney-client privilege, right? And did it in court, in public, and to the judge. He wasn't even allowed to hear that. Okay? So, always keep an eye on that too as well when you file a bar grievance. But always remember, pay attention to him, file a bar grievance due to some form of breaking the contract with that attorney, whether it's court attorney or not. Okay? And then, your next case, he's going to say something in that along those lines. He wants to step aside, but bring it. Judge, you're not even allowed to hear this. He just violated another deal, right? You're not even allowed to hear it. This is attorney-client privilege, okay? So, and I'm speaking wrongly, but you understand the point I'm trying to say, right? That's putting a chain around that attorney, and that judge is going to know that he's chained down to you. So your case may or may not go beneficial for you, but knowing that there's been evidence that you filed a bar grievance against that attorney, that you will do it again. And then if you happen to do another court case after that even, make sure you file the second one. That way it's clearly established to the judge, like, dude, I can't help you on this. And, you make consideration of that if the judge argue with it, file a judicial complaint on the judge, because he's not supposed to listen to that attorney wanting to leave that chain bound to you, that contract. All right, Diesel We the People News. Till next time, bye y'all. Oh, P.S. That's not legal advice. Okay, it's my opinion. All right, Diesel We the People News. Bye y'all.